Now, good afternoon, everyone. My name is Sharon Stewart. I am the Women Veterans Coordinator, South Texas Veterans Commission. I am a proud Army veteran. I spent 21 years, 6 months, and 20 days in Army, not that I counted. But my first 11 years, I was a photojournalist. And for the last 10 years of my Army career, I was a signal officer. I currently continue serving the veteran community as the Women Veterans Coordinator for South Texas Veterans Commission. And please note, here at the Texas Veterans Commission, we don't turn anyone away. Approximately 30% of the veterans I provide assistance to are in fact male. Now, since this event is open to the entire veteran community, this is probably not the time or place for me to mention that the Army beat the Navy on December 10th, 2022 in double overtime, and that the score was 20-17. So for the sake of building unity and camaraderie, I will not say go Army, beat Navy. I also won't say who, Roger that, you, this is me, or Wilco. And having said that, I again respectfully ask the audience to please keep your cameras off and mics muted until the Q&A portion of today's event. And I also ask that you refrain from asking any questions that could violate your privacy because this is being recorded. I really want to thank you for showing up for yourselves today. The team that's here today is taking time out of their busy schedules to share not only their passion for helping veterans, but also their expertise. Also, I'm going to ask you to be patient and flexible. Here in Texas, many of us have been affected by the winter weather, to include power outages. Now, we proceeded to have this event because the following information could be, and hopefully will be, life-changing. Now, before we get started, before I introduce the rest of the team, I'm going to give a quick overview of the Texas Veterans Commission. We are a state-level agency, and the services we provide are free to the veteran community. We have the Veterans Mental Health Department, the Claims Department, the Veterans Education Services, Veteran Employment Services, the Veteran Entrepreneur Program, Funds for Veterans Assistance, and we're one of the few states in the nation with a robust Women Veterans Program and a Healthcare Advocacy Program. And before the experts enlighten us today, I do want to mention that you can go to va.gov and request a copy of your DD214. And later on, I'm going to put a screen capture in the chat so you can see how to do that. Now, to tell you a little bit about the Austin Bar Foundation's Legal Assistance Program. They organize and provide monthly free legal advice clinics for qualified low-income veterans, active duty and reserve duty service members, as well as their families who reside in or have a civil legal issue in the jurisdictional areas at Bastrop, Blanco, Burnett, Caldwell, Gillespie, Hayes, Travis, and Williamson counties. But Miss Leslie Spatola has provided me some information that I will place in the chat so you can reach out to an organization that will provide legal assistance in other areas in the state of Texas. And also, please feel free to ask questions in the chat, or you can wait to the Q&A portion. And again, please keep your cameras off. Okay, so team, I'm going to just let you know who's going to be helping us out today. I do want to thank Miss Leslie Spatola, Project Coordinator for the Veterans Legal Assistance Program, and Mr. Doug Lawrence, Managing Attorney, Austin Bar Association, Veterans Legal Assistance Program. Due to the weather, he is not able to join us today, but I want to thank him for his willingness to do this. And also here to help us today are attorneys, Mr. Julian Honor, Managing Attorney, Texas Legal Services Center, Mr. Gerald Nicholson, Staff Attorney, Texas Rio Grande Legal Aid, Ms. Krista Harvey, Managing Partner, Harvey Law, and my fellow veteran, Mr. Gerald St. Clair. So team, thank you again so very much. I want to thank you for enlightening and equipping the veteran community with this valuable information. Now, for the sake of time, before anyone else's power go out due to the storm or any other issues, I'm going to go ahead and get started. And please post your questions in the chat. Myself and Dr. Krista Matthews will also be able to field the questions in the chat. Now, as we discussed, yesterday we got together and discussed some of the questions that will be that the team is going to provide information on. Now, I believe Mr. Honor and Mr. Sinclair, that you gentlemen can talk to us about the character service upgrades. And please feel free to do so at this time.
Good afternoon, everyone. I think I'll start out talking about this topic, and then our other panelists can jump in as they see fit or to add things at the end. Just to introduce myself, my name is Jared Nicholson. I'm an attorney who works for Texas Rio Grande Legal Aid here in Central Texas. I work with the Veterans Advocacy Project at Texas Rio Grande Legal Aid, helping veterans with a variety of issues, though most of my work focuses on VA issues and discharge upgrades. I am going to hopefully share my PowerPoint, so give me 1 second. Okay, hopefully everyone is seeing the PowerPoint. If not, let me know for sure. But like I said, we're going to talk about discharge upgrades as well as VA character of discharge determinations, and this will be just a general overview. My expectation is not to teach everyone on this webinar all the details that go into either of these proceedings. I'm just trying to bring up enough information so that you know sort of where to get started, what to include, and when to seek help if you need it. But I do want to cover both of these topics because they are often conflated and mistakenly thought of as the same thing, and they are different. And they have different processes and different applications and different ways of challenging the different outcomes that come with them. So let's just get into it. Okay, so we're going to go over the different discharge characterizations just to familiarize anyone who's not already familiar with the different types of characterizations. Talk about some of the different reasons people want to pursue discharge upgrades. Talk about the discharge upgrade processes that currently exist, and there are 2 different ways that you can go about upgrading a discharge. One involves the Discharge Review Board, and the other involves the Board for Correction of Military Records. These are both agencies within the Department of Defense, but they do have different rules, and different applications need to be filed if you're trying to get an upgrade from the different boards. And then finally, we will talk about the difference between just a straightforward discharge upgrade and the character of discharge determination process that goes on at the VA, and how you may be able to address some of your issues resulting from a less than ideal discharge status through a character of discharge determination appeal as opposed to a discharge upgrade. So first, it's always good to understand the different discharge characterizations. These are the common 5, and when I say common, I don't mean that they're that common. I just mean that there are some others, but those typically occur, say, if somebody is discharged during boot camp, you can get an uncharacterized discharge. But the most common for people who are discharged after serving are honorable. Most of us are familiar with an honorable discharge. That's the best possible discharge and entitles you to all benefits available to veterans. The next step down would be a general under honorable conditions. Sometimes you see this reversed and it'll be under honorable conditions with general in parentheses, but they're the same. And this discharge entitles veterans to all benefits other than the GI Bill. The GI Bill is the only veterans benefit that requires an honorable discharge. We then get into the types of discharges that are often called bad paper. That's not a legal term. That's just sort of a general colloquial term that people use to refer to less than ideal discharges. And I will probably use the term bad paper throughout this presentation. And that would refer to a discharge that is either other than honorable. This is a discharge status where you may be eligible for VA benefits after a character of discharge determination, which we will talk about later in the presentation, or you may be barred from VA benefits due to that character of discharge determination if you have an other than honorable discharge. The last 2 are bad conduct discharges. This is typically a discharge status that is going to bar you from VA benefits. It's not 100% certainty that you would be barred, but the likelihood is if you have a bad conduct discharge, you are not going to be eligible for VA benefits. And then the worst type of discharge would be the dishonorable discharge. of which you're not going to be entitled to VA benefits. And that type of discharge is really always the result of some serious misconduct, generally after a court-martial proceeding. So we actually don't see that many dishonorable discharges, though they do exist. You know, all of this information is reflected on your DD214. If you're a veteran, you are probably familiar with this form, but it is the military separation document that is going to contain information such as when you were discharged, when you entered the service, what branch of service you were in. And then for this presentation, most importantly, it's going to include your character of service, the narrative reason for separation, and any awards that are on there. But you know, it is on this document where you can find whatever that character of service is, whether it's honorable or other than honorable or bad conduct. It will be on the DD214. And when you're applying for an upgrade, what you are applying for is a change in your DD214. It is always important to think about what the reasons are for seeking an upgrade, because the reasons for seeking an upgrade are not only going to influence which venue you choose to file an upgrade in, but also might influence the strategies you pursue for reaching those goals. Some common reasons I am approached by veterans to assist with upgrades, I would say by far the most common is entitlement to VA benefits. You know, there's a whole host of VA benefits and healthcare, burial benefits, housing benefits, as well as cash benefits like disability, service-connected disability compensation, and VA pension, which all are tied to what your discharge status is. And if you have a discharge characterization that doesn't entitle to you those benefits, it becomes a real barrier to success. And that's probably the most common reason people approach me for discharge upgrades. The other is the GI Bill. As I said before, the GI Bill does require an honorable discharge. And so even people with general discharges, which are generally not barred from benefits, may want an upgrade just so that they can seek that educational benefit, which can have a lot of value. And then there are less tangible reasons people want upgrades. Sometimes it's as simple as people feel that they have been wronged by the military, that their service was not properly acknowledged, and they just want an acknowledgement that what happened to them was not right, and they want that kind of righting of past wrongs. Another less tangible benefit is that they just want to remove the stigma. You know, they want to be, they're proud of, they serve their country, they're proud of that service, and they want to remove the negative connotation that can come from, you know, a less than honorable discharge. And then, you know, in our integrated world where everyone has access to everyone else's data, you know, it's becoming more and more common that if you are applying for employment or you are applying for housing, they are conducting background checks, and your information that is contained on your DD214, such as your discharge status, becomes a part of that. And if you have a less than honorable discharge status, it can be a bar to employment and housing. And so, you know, these aren't the only reasons to seek an upgrade, but these are definitely the most common. And it's good to know what the goal is, because different goals can be addressed through different means. And sometimes different goals have to be addressed through different means. So let's look at that. So right now we're talking about discharge upgrades, which is the process through which, you know, you can get that DD214 characterization of discharge updated or corrected to reflect the improved character of service. In addition to just changing whether your character of service is honorable or dishonorable or somewhere in between, you can also change the narrative reason for separation and the separation authority on your DD214, which can be really important. Because if the purpose of your upgrade is, say, for employment purposes or to remove stigma, even if you get an upgrade that, say, other than honorable, upgraded to honorable, but the narrative reason for separation still says unsatisfactory performance or drug abuse or something else that is equally as prejudicial, such as, you know, trial by court-martial, something like that. Even though your character of service might be upgraded, your DD214 might still have some very prejudicial information on there that doesn't help you achieve some of the goals you're looking for. So be aware that it's not just asking them to change your character of service. It's often important to also have them change the narrative reason or the separation authority so that you don't have negative information on your DD214 that could cause you problems, even if it's not going to prevent you, say, from getting VA benefits. There are two avenues for seeking a discharge upgrade. The first is the Discharge Review Board, and the second is the Board for Correction of Military Records. And depending on the time since your discharge and the circumstances surrounding your discharge, as well as what you're hoping to change on your DD214, those factors will influence which one of these avenues you need to seek. So we will discuss both of them to kind of give you an idea of where to start. So, discharge review boards. This is often thought of as sort of the first option available and where you should start the analysis of what you're going to do. The discharge review boards have the authority to change the character of separation, so they can upgrade that other than honorable to a general or an honorable. They can also change the narrative reason, so they could change that unsatisfactory performance comment to something less or more benign, such as secretarial authority. And then it can also change the separation code, because the separation code, while not easily identifiable as to what it means, sometimes the separation code, if somebody knows what that means, will reveal just as much information or more information than the narrative reason. So sometimes you want to change that separation code to something innocuous as well. But it's important to note what the discharge review boards cannot do. They cannot change a discharge to a medical discharge. They cannot upgrade a discharge that was a result of a general court-martial. And they cannot reinstate enlistment of a discharged veteran or change the re-enlistment code for a veteran. So if you're seeking one of those things, you already know that you cannot avail yourself to the discharge review board. The other critical thing about the discharge review boards is there is a hard, non-flexible 15-year time limit from the date of your discharge that you have to apply for an upgrade. If you miss that 15-year deadline, there are no exceptions. You will no longer be able to apply for an upgrade from the discharge review board. So that's another critical factor to evaluate when you're deciding which venue to choose, is how long has it been since your discharge. In order to file for an upgrade from the discharge review board, there is a specific form. It's available online. It's a DD293. It's called an application for review of discharge from the Armed Forces of the United States. And you file that form with the appropriate board that corresponds with your branch of service. Now, the standard for upgrade at the discharge review board, which is essentially what is it that you have to convince the discharge review board of in order to entitle you to an upgrade, is propriety, equity, or clemency. Propriety is just a fancy way of saying, was the discharge correct based on the rules at the time of discharge? And is the discharge correct if we apply the current rules? So this is essentially, did the military or the branch of service follow their own rules for determining whether you should have been discharged with the discharge characterization that you have? And they also will consider, if there have been changes in the rules, whether a discharge that may have been proper in the past would still be considered proper under the current rules. I often think that the easiest example to illustrate that would be the don't ask, don't tell policy. During don't ask, don't tell, it was completely within the military's rules to discharge a gay service member, and they could have been discharged properly under the rules at the time. However, that policy is no longer in place. That has been changed. And if you have a discharge due to that don't ask, don't tell policy, you can receive an upgrade based on propriety, because under the current rules, you would no longer have received that discharge. The second area that you can receive an upgrade is called equity. And it is just a fancy way of talking about fairness. And the question is, was the discharge fair considering your overall character of service in light of whatever the misconduct was? So if you had a stellar service career and you were receiving letters of commendation and you were up for promotion and everything was going great, and then you had minor misconduct, say you had one incident of drug use, you may have an argument that in light of the entire overall excellent character of your service, that the one piece of misconduct isn't, that the resulting discharge isn't fair in light of all of that, based on that minor misconduct. The other one that is also very persuasive to the boards is, under the new guidelines, were there mitigating factors that warrant upgrade? The Department of Defense has identified in several memos, which we will talk about in more detail later on, a large number of mitigating factors that can be considered. The most common ones, or the most in the news ones, are new guidance on post-traumatic stress disorder, new guidance on military sexual trauma, new guidance on mental illness and traumatic brain injury. And if you can establish that you were experiencing symptoms from these conditions that may not have been properly evaluated or recognized by the military in the past, if you were experiencing symptoms and those symptoms contributed to the misconduct that resulted in you being discharged, you can argue that those symptoms are a mitigating factor that warrant an upgrade in light of how they impacted your conduct. The final area is clemency. This would be a basis for an upgrade at the Discharge Review Board only for cases where you were discharged as a result of a special court-martial. Again, you cannot apply for a change based on a general court-martial, but if it was the result of a special court-martial, you can essentially ask for an upgrade based on clemency, which is where it's more of a, I acknowledge that what I did was wrong, I accept responsibility for it, I've lived a long, productive life post-service, I'm a good citizen, and please upgrade my discharge just based on, basically a mercy standard of forgiveness. The key thing to note about discharge review boards is that you have to use the Discharge Review Board first before going to the Board for Correction of Military Records, if the remedy you are seeking is available through the Discharge Review Board. So if all you're looking for is a change in the characterization of discharge and a change in the narrative for separation, and you're within that 15-year time limit, you're able to receive what you want from the board if they want to give it to you, and therefore they force you to apply for an upgrade from the Discharge Review Board before applying for an upgrade through the Board for Correction. So you don't get to just choose which board you go to. If you can get what you want from the Discharge Review Board, that is the venue you have to choose first. Now, the Discharge Review Boards can't do everything that the Boards for Correction of Military Records can do. And so there are circumstances when you would want to jump straight to the Discharge or the Board for Correction of Military Records. The Board for Correction of Military Records can essentially correct any error on a DD214. And when you're asking them for an upgrade or a change in things, you're essentially claiming there is an error. This includes changes to a medical discharge. They can change the reenlistment codes, so you could potentially re-enlist in the military. And they also have the authority to upgrade general court-martial convictions. So if your discharge is the result of a general court-martial, the only place that you can get an upgrade is from the Board for Correction of Military Records. Now, there is a 3-year time limit to file an application with the Board for Correction of Military Records. However, unlike the Discharge Review Board that has a hard, fast 15-year time limit, the 3-year time limit at the Board for Corrections can be waived in the interest of justice. And while you will certainly, if you're filing after 3 years, want to explain to the boards why you think they should waive the time limit in the interest of justice, typically, in my experience, if the board feels that there is merit underlying the upgrade application, they will waive the 3-year time limit. In my experience, they are not in the practice of denying these applications based on the time limit, unless there's just no merit to the application. Again, you file an application for correction of military records. It's a DD114, so it's a different application than the board you file, or the application you file with the Discharge Review Board. But just like with the Discharge Review Board application, you will file this application with the corresponding board for the branch of service that you were discharged from. The standard for upgrade, they use different words to describe the standard in the regulations, but essentially the questions that they're asking are the same. And the words they use are error, injustice, and clemency. So if you remember from Discharge Review Board, theirs is propriety, equity, and clemency. So they've changed propriety to error and equity to injustice, but they essentially mean the same thing. So the error question is, was the discharge correct based on the rules at the time? And was the discharge correct if we applied the current rules, just like the propriety arguments that you would make for a Discharge Review Board application? Similarly, injustice is fairly close to equity, and that it's just an evaluation of, was the discharge fair considering your character of service, or were there mitigating factors that would justify an upgrade? The difference in the clemency standard at the Board for Correction, as we discussed, is they can grant clemency for discharges that result from any kind of court-martial, whether it's a special or general, whereas the Discharge Review Board can only grant clemency for discharge that result from a special court-martial. The other thing to know about the Board for Corrections is if you apply for an upgrade from the Discharge Review Board and are denied, you then have the right to file for a correction as long as that application is filed within 3 years of the denial date for your application for upgrade from the Discharge Review Board. And so while it's not technically an appeal of the denial from the Discharge Review Board, once you are denied by the Discharge Review Board, you then have the option to file an application for correction with the Board for Corrections. And they will review it anew, and they will make a separate decision that could agree with the Discharge Review Board's decision or actually change and upgrade your discharge as you're requesting. They have the authority to do that if they want. So if you are going to be thinking about a discharge upgrade, I highly recommend you review the specific discharge upgrade memos that have been issued by different secretaries of defense. And these upgrade memos are binding authority on the boards. So that it's essentially, a clarification of the law that the boards follow. And they address changes in Department of Defense policy relating to various issues that are relevant to upgrades. And specifically, the big ones are they address mental health, they address PTSD, diagnosed and undiagnosed. They address, allegations of military sexual trauma. And they also give a lot of guidance on what the boards are reviewing when we consider the concepts of equity, injustice, and clemency. And so all of these memos are going to be very instructive in sort of what types of evidence the boards consider and what types of evidence they think might justify upgrading a discharge. So it's important to familiarize yourself with those things. They're not complicated. They're written in plain language. They're not very long. I would say they all range from somewhere between 2 to 8 pages long. And so and there's really 4 of them that you should be thinking about. And these are all available online. You can just Google Hagel memo or Carson memo and they will pop up. But each one of them addresses a separate issue. And I just outline them here. So if you're thinking about an upgrade based on any of these issues, you know exactly the memo to check out. But if you're making an argument and it's related in any way to PTSD, the Hagel memo, the Carson memo, and the Curta memo are very instructive. The Carson memo also deals not only with PTSD, but also general mental health issues. The Curta memo deals with PTSD, traumatic brain injury, and military sexual trauma. And then the Wilkie memo gives excellent guidance on how to structure equity and injustice or clemency arguments. So if you're making any kind of equity, injustice, or clemency argument, you certainly want to look at the Wilkie memo to give you an idea of what types of arguments they will be responsive to. Because it is not enough just to say, I want my upgrade. you really have to give them a reason, either based on these standards of, is it in the interest of justice? Was there a violation of propriety? You want to couch your arguments in the terms that they use so that they will be more likely to be responsive to them. So just kind of in summary, to see side by side the different boards. So the Discharge Review Board, if you were discharged within the last 15 years, the discharge was not the result of a general court-martial, and the relief you're seeking is only to upgrade the character of service or to change the narrative separation, reason, or authority for your discharge, and you are not seeking a medical discharge, the Discharge Review Board is going to be the venue you want to pursue. The Board for Correction of Military Records is going to be available to you if you have already been denied an upgrade from the Discharge Review Board, if it has been more than 15 years since your discharge, if you are seeking an upgrade of a discharge that resulted from a general court-martial, or if you are seeking some form of relief not available from the Discharge Review Board, such as a change to a medical discharge, or you want to change in your re-enlistment code, or if, say, there's omissions to your awards and time of service. If you have those types of changes, those are also things that the Board for Correction can address that the Discharge Review Board cannot. And so that is how you can make that first decision, which is, which board do I need to file an application with? So once you've determined which application to file and where to file it, then what are the next steps? So both of these venues have a formal application form that needs to be completed. And depending on whether it's a Discharge Review Board or Board for Correction, it's either the DD214 or the DD149. But those applications can be deceptive in that they seem very straightforward and easy. I believe both of them are 2 pages long. It's very general information just about the veteran themselves, with very little opportunity to provide supporting argument or evidence. Do not let that fool you into thinking that is the only thing that you should submit if you want an upgrade. I highly recommend that before you file an application for upgrade, that you gather all of the relevant evidence that you can submit with that application. Now, there are ways to submit evidence after you have already filed an application, but if you've ever dealt with the military, you know it is a giant bureaucracy, and there is a high probability that if you do not submit everything together, that they won't be associated correctly, or at minimum, it is going to create delays in processing your application. So if you are able to compile all this information ahead of time, I recommend it. The evidence that I would recommend you go out and gather before completing your application is you're going to want a copy of your complete military personnel file. Some veterans have this because they're given it when they are discharged. If it's been a long time since you've been in the service, or if you don't have a copy of it, you can request it with an SF-180 form. You will also want your in-service medical records if you ever received in-service medical treatment. That can also be requested with the SF-180. If you've received medical treatment through the VA, you will want your medical records from the VA, which I put the form, you can request that on there for. And if you've ever filed a claim for VA benefits, even if you were denied, you will want a copy of your VA claims file, which can be requested with a VA 3288. The other non-military records that you will probably want to gather, if you have non-VA medical records for post-service medical care related to a condition. So if you're going to allege PTSD as a basis for an upgrade, and you've been receiving treatment for your PTSD from a non-VA facility, you would want to request those records and submit them, because it is highly likely that the discharge review boards or the Board for Corrections won't have that information if you don't supply it to them. You will also want to prepare a personal statement, which will be your own version of events of what happened, what you were experiencing, what actually happened with the misconduct. I also will include, if it's been a long time since you've been discharged, what you've been doing since you got out of the service, and also why you want an upgrade. I do think it is important to let the discharge review boards know what the purpose and behind your upgrade is, because say the purpose is that you want access to the GI Bill, and you have an other than honorable discharge, in my experience, there's a lot of times the boards will just upgrade those other than honorable discharges to general discharges because they think, oh, we're giving this person access to all these VA benefits. But if the specific reason you want the upgrade is for the GI Bill, that's not good enough. And so you want to make sure the board knows that in order to give you an upgrade that satisfies your goals, they need to go to honorable. And if they're giving you something less than honorable, they're not actually giving you what you're asking for. So make sure that you point that out to them if that's the case. Also, if you have buddy statements from people that you served with who can corroborate critical pieces or things that you're claiming, such as, if you experienced a traumatic event in the military that contributed to your PTSD, and you can't verify that event by your in-service records, if it's not explicit in there that you came under fire or you were wounded in combat, sometimes you will need buddy statements to help corroborate that you actually came under fire or that you were in combat or that you experienced whatever event traumatized you that contributed to your PTSD. And also, if you've been out of the service for a long time, or if you are filing your application based on clemency, it's also very helpful to get character references. These would be statements from people you know and who know you, who can attest to what kind of person you are, what kind of person you've been since your discharge, how the discharge has impacted your life, and what an upgrade would do for you individually. They can be very persuasive. Now, obviously, I tend to recommend if you know people of certain standing in your community, whether it's, your pastor, or if you, are part of veteran service organizations and you can get a character reference from somebody who was in the military. I tend to think that the boards view those types of character references with higher regard than just, say, a friend of yours who's got no association with the military or no connection to the community. But any kind of character reference can be submitted and can be helpful. So once you have gone out and requested and received all of that information back, which can take quite a bit of time, the VA claims files right now are taking over 6 months to get back. So just be aware that it could take a long time to get all of those materials together. But once you have all of your materials, the things that you would want to submit as part of your discharge upgrade packet, you need to submit the application form, and you need to pick the appropriate form for which board you're going with, whether it's the Discharge Review Board or the Board for Correction. They also want you to submit a copy of the DD214 you're seeking to correct. So for a lot of people, they only have one DD214, but some people get issued multiple DD214s if they've had multiple periods of service. And so, you want to make sure you're submitting the DD214 you're seeking to correct or upgrade. We always submit a letter, or that we call a brief. That's kind of a legal term, but there's no set format for it, but essentially it's where you lay out all of the reasons or arguments for why you believe you qualify for an upgrade under the standards we talked about previously. So if there were errors made, you want to point out the errors and explain what actually happened and why those errors violated the rules the military had in place or have in place now. Or if you're making, the equity arguments, and you're trying to establish that you had undiagnosed PTSD, you're going to point out to the boards that you have this undiagnosed PTSD, and you're going to want to point to any evidence that you've been able to gather, whether it's post-service treatment or in-service events that establish that you may have been suffering from PTSD, even though you didn't have that diagnosis due to a variety of reasons. You'll want to include your personal statement, your buddy statements, and then any relevant military or medical records, as well as your character references. So essentially anything that you're claiming or describing in this letter, pointing out your arguments, you want to be able to show them evidence that you've gathered to support those claims. And again, they come primarily from this batch of places. Your personal statement is a big part of it because it's going to include things that aren't in your military or medical records. Your military records are important because they're the baseline from which the military is going to start the questions about your upgrade. They're going to start by reviewing your military records. And then your medical records. If you're claiming mitigating impacts of mental health or military sexual trauma or PTSD or TBI, you want to be able to support those claims with medical records that can at least establish that you were experiencing symptoms. And so all of that gets put together and it gets sent in to the appropriate board. I always recommend, if you're mailing these in, which is the preferred method, that's how they ask you to submit them, that you mail it certified with return receipt. Keep a copy of it for yourself, just so that you have documentation proving when it was submitted and you get confirmation that it was received. If you go to the different board websites, they do have an email address where you can check the status of your application. These applications take a very long time. I would say right now, the Board for Corrections applications have been taking somewhere between 1 and 2 years. And I have discharge review board applications that have been filed over 3 years ago that we're still waiting for answers on. So you do want to occasionally, I wouldn't say do it that often, but once every 3 or 4 months, you may want to shoot an email to the different boards just asking about the status of your application, and you're going to get 1 of 2 emails back. You'll either get an email back saying that they have received it and they are processing it and to be patient, or you'll receive an email saying, we've issued a decision. And sometimes they issue decisions and they don't get mailed out, which is why it's good to check on them. But if they haven't mailed you one, they usually will provide for a means of getting an electronic copy if a decision has been issued and you did not get one. Now, that is a very quick overview of the discharge upgrade process. Again, my goal with that was not to teach you all how to do a discharge upgrade. If anything, it was to show you that it's a more complicated process than we are often led to believe. I have many veterans who come to me saying that they were told that all they have to do is wait 6 months and then apply for an upgrade and they'll get it. And those veterans tend to think that if they just fill out the 2-page form and submit it, they're going to get an upgrade no problem. That is not my experience. You certainly need to supply more information than just the application, and the rate of approval for upgrades is low. It's definitely below 50%. So don't take it lightly. It is a process that is difficult, and it's something that you would be benefited by if you had representation. So if you have the ability to get help by either the TVC or a veteran service organization, or if you qualify for some of the legal aid programs like my own, just as a selfless plug, the Veterans Advocacy Project at Texas Rio Grande Legal Aid helps eligible veterans, and we do discharge upgrades. You do have to be financially eligible, and our criteria is that you have to be below 200% of the federal poverty guidelines, which vary based on your household size. But I highly recommend you, if you want to do this process, that you try to seek help because it is complicated. The other thing I wanted to talk about on this training was VA character of discharge determinations, because not everyone understands that there is a difference between the VA character of discharge determination and your actual discharge status. And if you want to challenge a VA character of discharge determination, that's not an upgrade. But if you're successful, it can provide you access to VA benefits. So I wanted to talk about it because many people, that's the primary goal of an upgrade, is VA benefits. So just to give a little bit of an overview, in order to receive VA benefits, the full slew of healthcare benefits, pension benefits, disability, service-connected disability compensation, it requires that you have a character of service that is not dishonorable, which this is where some of the confusion comes from, because you hear dishonorable and you think dishonorable discharge and you say, hey, I don't have a dishonorable discharge, I should be eligible. It's a different standard than having a dishonorable discharge. And the way they do it is if you have an honorable discharge or a general discharge under honorable conditions, you automatically pass that bar. You are automatically, your discharge character of service is considered not dishonorable. Now, if you have a dishonorable discharge, your characterization is going to be considered dishonorable. So that leaves two circumstances other than honorable discharges, and in very limited circumstances, bad conduct discharges, where you could have an other than honorable discharge. And I'm going to talk about other than honorable discharges just because it is extremely unlikely that if you have a bad conduct discharge, you're eligible for VA benefits. It's not 100% certain, but it's pretty close to 100% certain. But with other than honorable discharges, there's a lot of gray area. They classify other than honorable discharges. They can go either way. They can either classify them as not dishonorable, or they can classify them as dishonorable. And if they classify them as dishonorable, they will deny you from benefits. So every time somebody with an other than honorable discharge applies for VA benefits, the VA has to do a character of discharge determination to determine whether they classify your discharge as dishonorable for VA purposes. Again, different than a dishonorable discharge from the military. What's important to know about this is that if you get a denial based on your character of service determination, you can appeal that determination the same way you would appeal any other VA decision, which is through a notice of disagreement, which has a 1-year time limit. So if you apply for VA benefits and you're denied for this reason, I highly encourage people to consider appealing through a notice of disagreement, even if they're already applying for a discharge upgrade. They're two separate processes that have two different review standards and are done by two different agencies. They're completely independent, and you can do both at the same time. And I encourage people to do both if the purpose of wanting an upgrade is for VA benefits. So the thing to know is that when they evaluate these other than honorable discharge, what they're looking for is this person barred from VA benefits based on the regulations? And there are certain types of misconduct that can result in an other than honorable or bad conduct discharge that are just flat out barred from receiving VA benefits. And I've listed some of them here. Conscientious objector, people who are sentenced by general court-martial, resignation for good of the service, AWOL for 180 days, desertion, mutiny, spying, if you accept an undesirable discharge to escape trial, moral turpitude, and persistent and willful misconduct. Now, the last two on this list are the ones that provide the greatest opportunity for success on an appeal. If your misconduct, if your discharge resulted from a general court-martial, you're not going to be successful on an appeal. You're going to need to upgrade or receive clemency for that general court-martial before you could receive VA benefits. There's not a lot of gray area there. However, what is considered misconduct that is moral turpitude and what is considered misconduct that is persistent and willful, those things are up for a lot of interpretation. And there are times when the VA will take an isolated incident, say something like, I keep coming back to the same example, but like a one-time positive drug test, and they will discharge somebody with an other than honorable, and they will be denied VA benefits. And the only real grounds that that could possibly be under would be moral turpitude or persistent and willful misconduct. And we've had a lot of success challenging those decisions by successfully arguing that one-time marijuana use is neither moral turpitude or persistent and willful. And we have been successful in winning those. Again, I'm not trying to tell you how to win one of these appeals. I'm just trying to make you think about the circumstances under which you may want to consider appealing a denial of VA benefits because of your discharge characterization that can be done separate from or in conjunction with an application for upgrade. And you may have a greater chance of success winning an appeal of a denial of VA benefits than you would an upgrade. And you want to give yourself as many possible chances to be successful and accomplish your goals, because the reality is that the chances of success on either of these is less than ideal. It's not that significant, it's low. And again, I don't say that to discourage you from doing it, because you should. I just want you to be aware that, do not take it lightly. It is not something that they give away freely, and it is definitely something you want to put your best foot forward.
So I know Jared talked a little bit about criminal court in the military. I know nothing about that. I wish I did. But I do know a couple of things about the state of Texas criminal court. Whether or not I like it, I'll keep those opinions to myself. But they asked me to talk just a little bit about the process and some options for cleaning up your record afterwards. Before I get into telling you the answers for things, I wanted to kind of lay a basis of vocabulary so that I'm not just throwing legal jargon at everybody and like no one can follow along, because it's a little complicated. So to begin with, what is a conviction? There's two elements you need to have for conviction. One is a finding of guilt. So when you accept a plea offer or talk to a judge, you say either I'm guilty or you can plead no contest. And that means like I'm not saying I'm guilty, I'm not saying I did it, but I'm not going to fight for my innocence at all. I'm just going to say, you can find my guilt, which a judge will. They'll say, okay, I understand you're pleading no contest, but I'm going to find you guilty. And then the second part is you have to face some sort of punishment for it. It could be probation, it could be jail time, it could be the little thing you blow into your car to make it start. These are the different kinds of outcomes that you can have for your case. We call them dispositions. Some of them are the convictions that we just talked about, and some of them are not considered conviction. So the first one, which is, probably what everyone thinks about, is jail time. So you could have time to serve or you could have time served. Here you are found guilty and the judge has adjudicated that guilt for a punishment. So this will be jail time. So either you have credit. So if you get arrested and you spend the night in jail, sometimes they'll say, okay, well, you've spent enough time in jail, so we'll give you credit, but you're going to be convicted for jail time. Or they're going to say, no, you have to go back to jail or you have to stay in jail for time to serve. Second is, probably people are familiar with this one, it's probation. So again, you're found guilty and the judge is going to adjudicate your guilt for a punishment. It is a jail sentence, but it's probated for X amount of months or years. So you can be sentenced to 30 days in jail, but they say, okay, we're not going to make you go back to jail, but we're going to put you on probation for, let's say, 12 months. So if you go through that 12 months, following all the rules, you don't get in trouble, then you're done. You can be, you don't have to go to jail, but there is a conviction on your record. If you don't complete it successfully, you go back to, okay, maybe you have to go back to jail. Third one is pretty similar to probation, but it's a little more complicated. It's called deferred adjudication, which you tell the judge, either no contest or I'm guilty, and the judge finds you guilty, but she doesn't do anything with it yet. So there's no jail time, no underlying sentence like there is probation, but all the requirements that you have to do is basically probation. So if you complete it successfully, the charge gets dismissed. So in probation, you have a conviction, but in deferred, you don't have a conviction at the end. The charges are dismissed. But if you don't complete it successfully, then you have to go back to either jail time or they'll change it to probation. So it'll be a conviction. They usually give you a couple freebies, but generally, and my clients don't typically like to follow the rules and they don't usually successfully complete it, but that's neither here nor there. So that's deferred adjudication. And then you have pretrial diversion or intervention. Technically, on the application, you have to either plead guilty or no contest. Typically, they make you plead guilty, but you kind of keep it a secret from the judge. So there's no adjudication of your guilt. And typically, it requires some classes. Again, nothing you have to blow into to start your car, some community service, some fees, things like that. And if it's completed successfully and you follow all the rules, it'll get dismissed. Or sometimes they don't file charges at all. So I have a client right now, she stole some stuff from Walmart. She has to take a class about how stealing is bad, and then they won't file formal charges. So it won't say dismissed. They'll say no charges have been brought, but it'll still show an arrest on her record, which we'll get to in a minute. And then lastly, there's acquittal, which means you're found not guilty affirmatively. I see a question, but I don't think that's for me. And then we'll get to, if I can change my slide. Special court. So for pretrial intervention, usually you get kicked to a special docket. There could be a mental health court. So one of my clients, he maybe didn't do a great thing, but they said, okay, he probably wouldn't have committed this offense if he didn't have some sort of mental health issue. So he gets put to the mental health docket, and if he takes his meds like he's supposed to, stays out of trouble, then they'll dismiss his charge. Or there's juvenile cases, same thing. We don't want to cloud someone's record when they're 17. We want to give them a chance to get a dismissal. The most common one is probably a DWI or drug class, which you have to go to AA, you have to have drug testing every now and again, and then they'll dismiss your DWI or possession charge after you've done those things. But most importantly, for this CLE or presentation is Veterans Court. So for Veterans Court, I feel it's a little more intensive court docket. You have to possibly go to treatment, either inpatient or outpatient treatment in a VA hospital, usually. You have to go to a group therapy setting. All of the people in the group are going to be either active or former military. And those are, pretty frequently, but actually I forgot I listed all this in the next slide. But I do want to mention that not all counties have all of these options. Some counties have none of these. I know here in Travis County, Bell County, Williamson, and Hayes County, they all have veteran court options. But places like Wichita Falls, Wichita County doesn't have these. Okay, and I know I mentioned a few of these, but this is a list of requirements. Usually Veterans Court have, and it could be 12 months or it could be 24 months, depending on the person, nature of the offense, criminal history, things like that. But I think the biggest benefit they want people to have is having a group of other veterans that you can lean on and go through the process with. You'll have, more things in common. It might be more effective that way. Okay, now the bad news, the worst news I have about this is that your background check will always show an arrest. Even if you get it dismissed, it'll still show that you were arrested for something. Now, depending on the outcome of your case, what comes after that will either be a conviction or it'll show dismissed. But generally, anytime you're arrested for offense, it'll show up on your background check. If you plead to a jail time or probation, it'll show that you were charged with that offense and convicted of it. If your county has an online portal, it'll actually tell you what you pled to. So you could see that that person pled to 30 days in jail. For deferred adjudication, it'll show dismissed. For pretrial, same thing, it'll be dismissed, and acquittal will be dismissed. I know it sounds unfair, but those will show dismissed, but will still be on your record if you complete them successfully or if you're acquitted. Now, how you clean up your background check, your record, you have two options. You could do a non-disclosure or you can get an expunction. The non-disclosure hides your criminal record from the general public, but the government and some licensing agencies can still see it. So if you're convicted of offense and you want to apply to nursing school or you want to go to law school, I don't recommend it, but you would still have to disclose that and they could still see the records. But like a general, if you're applying for an apartment or a job, typically they can't see it. Now you can only get a non-disclosure if you completed deferred adjudication or pretrial. So if it shows a dismissed. Sometimes it can be automatic if it's your first offense, your first misdemeanor after 2017, and the judge has to order it within 6 months. Sometimes you have to remind the court because they don't care about you, but the judge should order it. If it's not automatic, you have to affirmatively ask for it, and sometimes there's a waiting period. Most misdemeanors, things like a DWI, you can apply for it immediately, but for other misdemeanors, including firearm offenses, you have to wait 2 years. And then for a felony, it's 5 years. I've listed on the right side all of the things that you cannot get a non-disclosure for. Regardless, those are pretty serious charges, so it kind of makes sense. I do have a personal story for more of a picture of it. My husband was arrested for unlawful discharge of firearm when he was 12. And the judge told him, don't worry about it. It'll fall off your record. No one will be able to see it. And then when he enlisted in the Army, they were like, hey, what about this firearm charge? And it turns out the judge meant he could get a non-disclosure, not an expunction. So just a fun story that he gets to tell. Now, an expunction is, there's a narrower eligibility for it, but it permanently removes and destroys entries from your criminal record, so no one can see them. Even the government, even licensing agents, they can't see it, but you have to file a petition. And when you file it with the state, any agency can say, actually, I don't think this guy should get an expunction, and they can deny it based on that. And you're only eligible if you have deferred adjudication for a Class C misdemeanor, which is, your traffic tickets, public intoxication, things like that. Or if the charges were dismissed or the person was acquitted, but that will only be for pretrial diversion or acquittal and not for deferred adjudication. So for a non-disclosure, you can use deferred adjudication, but not for an expunction. And there are waiting periods for expunction as well. For a Class C, so those public intox, traffic tickets, it's 180 days. And for a Class A and B misdemeanor, typically your first DWI or something like that, it's 1 year. And then for felonies, it's 3 years. I find it kind of unlikely that you would get an expunction granted if you had a felony, but I haven't tried, so I don't know for sure.
Thank you so much, Chris. That was some phenomenal information. Thank you. I didn't realize your husband is probably my second or third cousin. I'm just saying that because he's an Army vet. So that is why I like you so much. No, I'm just
I'll take it.
Okay. Well, and I just want to thank the team so much for this wonderful information. At this point, I'm going to go ahead and stop recording because